court to consider fully. Therefore, I conclude that it's within my province and based on this record that a dismissal with prejudice on those three cases, those three counts is appropriate. The court is granting the motion over your objection, and we are going to move now to your motion.
Thank you.
Argue that now as you're trying to say something.
Thank you, Your Honor.
Your Honor?
If I could have a moment. He's been asking me to explain something to him. If I could just have a moment to...
No.
Oh.
I have something to say.
No, you don't, sir.
But I do.
You speak through your lawyer. Your lawyer has the right to represent you.
Help me help you.
And that's what's going to happen right now.
Those other two counts of stalking show that they have weaponized the government against my First Amendment rights.
Okay, I'm going to stop you right now, and I'm going to tell you something, sir. If you think this trial is going to be about some sort of give me liberty or give me death moment, and I'm going to allow it to turn into some request that the jury nullifies what I'm going to instruct them on the law, think twice. That is not happening in my courtroom.
So you're going to assist them in weaponizing the government?
Please or I will find you in contempt and you will be held. That's right, sir. Officer for purposes of trial. Mr. Olson, come on up. And I'm not critical of his arrival, given the court placing this on the calendar at a very rapid pace this morning. The court notes that there's a request for Officer Brandon Pipp to be the court officer. We discussed that last time. The court did indicate, and there was objection filed by, argued by Mr. Singleton in terms of order of witnesses. So I'll leave that for a minute. There are other requests for motion eliminating from the state, which frankly I view as being more standard, so I'll inquire of the state regarding that. The state also filed proposed jury instructions, and from those jury instructions, I now discern that the state is not pursuing two stalking charges against victims B and C. I discern that because the only stalking instruction that was provided related to victim A. I also believe that the state is not pursuing the possession of marijuana charge because I don't see any instruction included by the state. After, I've just been handed, but it was forecasted apparently in exchange and communication between the clerk and counsel in setting this up today, and then a letter filed by Ms. Thompson later this morning, which I reviewed just minutes before having called the case. I have now received a motion from Mr. Singleton seeking to adjourn the trial next week, and we'll get into that. Let me turn to the state first. Ms. Thompson, can you at least give me some idea of why this is being filed today as opposed to when we discussed on Wednesday?
No, it was my oversight. I don't have a good reason.
Okay. Has everything I've characterized relative to the state's pursuit of charges against the defendant, is what I've said been accurate?
Yes.
So is the state, in essence, moving then to dismiss certain counts of the information?
I am moving to dismiss counts 2, 4, and 6 in the information without prejudice.
and that would be the 2 stalking counts against victims B and C and the possession of marijuana charge.
Correct.
I understand you have a motion to adjourn, but I want to take up that motion to dismiss. Is there any objection by the defense to the dismissal of certain claims?
Your Honor, I think we have no objection as to the dismissal of count 4. How the court would choose to go forward on my motion to adjourn may impact whether or not we would prefer to leave the other remaining stalking charges on the going forward. Mr. Olson, I had a brief conversation this morning. We've been trying to plan for the various scenarios that this is presented. However, Your Honor, I think that decision is largely characterized in part by the timeline that we're on right now, and so I don't know that I'm in a position to offer whether there's an objection to the dismissal of counts 2 and 6 without a conversation with Mr. Olson, and we would hope that the discussion of the motion to adjourn would be considered before that.
Okay, so certainly I'll give you a chance to talk to your client. Do you want to talk to your client right now?
Well, again, yes, Your Honor, if that's my choice,
Sure.
but if we're going to pursue the motion to adjourn, I would prefer to do the conversation with him afterwards so we could consider that in our conversation. But
Well, you get to go at my order. I'm
Right.
taking up this first because, frankly, it does not make sense to me, whether this matter is tried on Tuesday or some other day, that there would not be a thoughtful and substantive consideration about the state's moving to dismiss certain felony level charges that they had previously brought against your client. So I'm a little confused why that would be a difficult conversation, but I certainly recognize that this has been placed on the calendar. It's not, by the way, also something that was not forecast as a potential. It's been talked about for 2 weeks and talked about again on Wednesday. So I certainly will give you a chance right now, given the fact that Ms. Thompson's making the motion here on Friday, September 26th. So I'm going to turn up the sound barrier so you can speak freely without being overheard. Go ahead.
Nathan Pursuit. I object to dismissing the other 2 stalking charges because it just amplifies the persecution that's been happening, and also brings attention to the text messages that talk about my grievances, and we've been avoiding that. So make them pursue it.
or make them at least have the jury find not guilty.
Yeah.
You understand that you are tripling mostly your
Yes, I
expenses.
understand.
Fully understand that.
I understand.
Okay, Your Honor, we are ready to proceed.
All right, Mr. Singleton.
Your Honor, we object to the dismissal of counts 2 and 6 on the grounds that this matter has been pending for substantial time. A dismissal would place Mr. Olson in the position of basically responding at this point to the entire course of, or the entire set of events, which is all overlapping and likely evidence towards each incident or each contact with each alleged individual is likely evidence of, or potential evidence of, stalking in its own right as to each other, as each of the victims. That places Mr. Olson essentially in the position of having this trial, and then if the state is not satisfied with the result of this trial, bringing back the same 2 other alleged victims in a separate later trial, facing essentially the same facts, the same witnesses, and giving the state another bite at the apple, a kick at the cat, double jeopardy, although we're just calling it now stalking of a different individual who is associated with that location. And so after years of preparing for these trials, having to try to be somewhat prepared to address these various contacts, which are everything from slicing of tires to sitting on a bench with reading a Bible, and not knowing what the government is going to allege as evidence of stalking against which of these alleged individuals. Now, parsing these out later on into potentially 3 later trials, Your Honor, in succession, violates his right to against double jeopardy. It violates his right to, Your Honor, and I understand this is somewhat contradictory in my given my adjournment motion, his right to a trial, speedy trial, which is not wholly required, or a demand does not need to be necessarily made for an individual to retain the right to a speedy trial. And so, Your Honor, there's a question of prejudice. Also, Your Honor, I'm not entirely sure that the reason that the state is dismissing these charges now at the last moment is not because it failed to obtain the participation or the willingness of individuals to attend this trial. And so it may well be to basically sidestep any of the other court's orders in terms of, making us proceed at this trial date. So, Your Honor, I understand.
So let me stop you for a second because I want to make sure that your argument is what the state. I want to make sure I clarify what the state's motion is to see whether or not that this is really disputed. I assume, and maybe I should say it out loud, that the state has made an assessment as to its ability to proceed to trial as to all charges, and it has determined that it is not able to proceed to trial scheduled on Tuesday as to counts 2, 4, and 6, and therefore is dismissing those and is doing so with prejudice. Is that correct?
No, I asked for them to be dismissed without prejudice.
So, why should I do that if we have been set for trial for all matters as of Tuesday? This case has been pending for 2, 3 years. So why should I grant that request, and why should the state be able to refile in the future if it somehow believes it can in the future prove that case? Do you have support for that, legal support?
Well, I think the case law says that the court has authority in this situation to dismiss with prejudice pre-trial if the court finds that there is a violation of a constitutional speedy trial demand. So I think the court can dismiss without prejudice, with prejudice. I'm asking that it be dismissed without prejudice. I am not able to proceed on these counts on Tuesday, and I'm not asking for an adjournment so that I can hopefully be ready at a future date without a guarantee. This case should go forward to trial. I have assessed my evidence, and in considering that and my ethical obligations, I don't believe I can prove those counts beyond a reasonable doubt. I've never had an objection to a request for dismissal before.
Well, I think that the objection isn't to the dismissal. The objection is to the potential that this is not concluded. And I hear two things from you. I hear you want to keep reserved future potential, but you cannot. You've assessed your case and you've determined, and this is not shocking to me because you've been very direct about this, you have assessed your case and determined as to those 3 counts that you're moving on, that you cannot proceed to trial and prove the case beyond a reasonable doubt. And this case in particular has been pending for some time. The state has been granted adjournments previously, primarily due to witness difficulty because of the location of witnesses. But nonetheless, there's been this elongation of time related to this case for the purposes of assessment moving ahead. And so it doesn't seem to be, and I understand you agree that I certainly have this within my capacity to consider the dismissal with prejudice.
Your Honor, I'm sorry.
Just a minute. But you're asking me to sort of leave the door open for future events unknown at this point with respect to this defendant. And so from my perspective, that's a non-starter because we've been set for trial as to all issues. They've been on the calendar. Mr. Singleton came in, I adjourned the trial as a result of that moment where there were issues related to being able to proceed, which gave additional time. I just feel that this matter is either a put up or shut up moment relative to the questions the state, and I'm critical of the state. This has to occur, where there has to be an evaluation of your capacity to meet that standard, and there's an ethical obligation as a prosecutor. If you feel you can't make it, then you gotta move on, and that's what you're doing in essence here. But you're also trying to reserve your right to be able to move on in the future. So I understand counsel's objection. I understand the state's motion. The court is going to grant the motion over the objection of the defense. I'm going to dismiss counts 2, 4, and 6 at this time, and I'm going to do so with prejudice, with the acknowledgement that that is within the capacity of the court to do so in light of the procedural history of this case. Therefore, this matter will proceed on one felony count of stalking, one misdemeanor count of criminal damage to property, and I believe there is a misdemeanor count regarding possession of drug paraphernalia that is still pending. Those are the 3 counts that are continuing. Have I missed any?
No, that's correct.
All right. Let me move then to your request for adjournment. Do you want to have an opportunity to make any record regarding that?
Yes, Your Honor, and I apologize. I'm not trying to argue now against myself again. I've reviewed the cases regarding dismissals of prejudice with courts who both have attempted to do it essentially without reviewing the existing case law, and at least in one instance after specifically reviewing the case law as to the specific findings that need to be made by the court before it has the authority to do so. And I don't know if I've ever seen a court successfully dismiss a charge with prejudice in a manner that has overcome subsequent court of appellate review.
So my review of those cases involved typical cases where there is frustration with the state regarding their diligent prosecution of a matter, including one case out of this jurisdiction, Waukesha County, Judge Rogenhagen, where there was a dismissal with prejudice of a sexual assault case and an appeal by the state regarding that. Number one, that's not this case. Number two, the court addressed the history of this case relative to length of time and adjournments that have been previously granted, and the fact that this matter has been before the court, and we are at the 11th hour in terms of the preparation for trial, and the trial will be on all matters. Number three, the state is acknowledging this court's ability to exercise a conclusion in this case over their request, which was a dismissal without prejudice, to allow this court to consider fully. And therefore, I conclude that it is within my province, and based on this record, that a dismissal with prejudice on those 3 cases, those 3 counts, is appropriate. The court is granting the motion over your objection, and we are going to move now to your motion.
Thank you.
If you want to argue that, now is the time to say something.
Thank you, Your Honor.
Your Honor?
If I could have a moment. He's been asking me to explain something to him. If I could just have a moment.
No.
Oh.
I have something to say.
No, you don't, sir.
But I do.
You speak through your lawyer. Your lawyer has the right to represent you.
Help you.
And that's what's going to
We're in a
happen
good
right
spot
now.
right now.
Those other 2 counts of stalking show that they have weaponized the government against my First Amendment rights.
Okay, I'm going to stop you right now, and I'm going to tell you something, sir. If you think this trial is going to be about some sort of give me liberty or give me death moment, and I'm going to allow it to turn into some request that the jury nullify what I'm going to instruct them on the law, think twice. That is not happening in my courtroom.
So you're going to assist them in weaponizing the government.
Talking, or I will find you in contempt, and you will be held. That's right, sir. So I'll give you a chance to talk to your attorney, because this matter has come up very quickly, and I'll allow him to counsel you. He's skilled. He's knowledgeable. Listen to what he has to say. You don't have to accept what he says, but you should hear it. Put up the sound board.
Dismissal with prejudice is exactly what you want.
It exposes them.
Would you listen to me?
They have to pursue those counts. It exposes that they have weaponized the government against my First Amendment right.
Can you listen to me? question about he has the jurisdiction to go ahead and make this decision.
I
I have
don't.
never had a dismissal of prejudice in the entire time I've been an attorney, and I have
don't
fought
want it.
I have already objected to it, but it means that we are. Look, I'm here to go.
I said my piece.
Thank you, Your Honor.
All right, Mr. Singleton.
Your Honor, and I apologize. I think there was some confusion about prejudice, what that meant in the course of this.
You don't have to explain. I
So-
just want you to proceed with your argument.
Thank you, Your Honor. I appreciate the court's consideration of the prior decision. I am maintaining my request for an adjournment for basically the same grounds that we had before. I did expect when we came here that these issues regarding the outstanding, which charges he would be facing, would likely be addressed today. However, Your Honor, it doesn't change the fact that the state has now gone from 15 witnesses to some set of eight witnesses who I don't know who they are yet. There still has not been a filed witness list. The witness list we've received has not yet provided addresses or contact information for the witnesses who we would call. Once I receive those 8 witnesses that the state intends to call, I need to go back and look at which events I would like to try to admit.
Let me just stop you. The state did file a witness list. That witness list contains 17 witnesses. The state's indicating that they're calling 8. I assume, Ms. Thompson, that the 8 that you are calling are within the 17.
Yes.
And you want to identify for the record the 8 witnesses that you will be calling or plan to call at trial?
I can. I don't think I have to, but I will do it for the court.
Well, you have to do it if I tell you to do it, so I'm asking you to do it.
Craig Drummey, Christopher Foster, Timothy Gibbons, Brandon Pipp, Jacob Olenek, Roger Painline, Kyle Stonez, Nicholas Mastrocola.
Thank you. Counsel, regarding your issue of adjournment, any other comment?
Your Honor, I would rely on my brief.
Thank you. From the state, any response?
No, I think a lot of what is in counsel's brief is inflammatory, so I object to the adjournment as I stated in my letter.
Okay. So this is my view of life. The matter has become narrower, not broader. Therefore, I understand the concern of the defense that somehow that they're being treated unfairly, but I don't believe that to be the case. The issue has always been present in a broader fashion relative to the charges, including the charges that have just been dismissed. The witnesses, the state has provided a listing of, which is broader than the witnesses that the state intends to call. So the court doesn't believe that the matter has become more unfair, if I can use that characterization, to the defense. I think it has become less, because there is a more focused presentation as to what the state intends to pursue relative to their burden. They get to go first, and they carry that burden of proof. So I believe that the matter is appropriately set and will be tried on Tuesday. Therefore, the court will deny the motion to adjourn at this time. Before we break, I'll see you at 8:15 on Tuesday. Is there anything else? Oh, and I'll grant the request for the court officer. Was there any response to the request regarding timing of testimony of that officer? Have you put any thought into that, Ms. Thompson?
I don't anticipate he would be called until probably later in my case in chief.
Okay. And that's different than what you requested, Mr. Singleton?
Yes, Your Honor.
All right. The court has had officers in this court previously, and I will grant the state the right to have a court officer. And it appears that Mr. Pitt's relationship, Officer Pitt's relationship to the investigation, and therefore is an appropriate individual for purpose of that classification under the Wisconsin statute. The court has had court officers that have been held until the very last witness in cases. I've had them testify in the middle, I've had them testify at the beginning. The court doesn't find in this particular case that there's anything untoward or unfair about that, given the statutory authorization for the recognition of the court officer. Therefore, the court will anything else before we meet again on 8:15 on Tuesday, Ms. Thompson?
The only, additional substantive motion in limine that was on my filing this morning is the number of prior convictions of Mr.
Oh.
Olson, but we can address that if he chooses to testify. It should only be one.
And that should be a discussion between you and Mr. Singleton.
Sure.
And I'll let Mr. Singleton weigh that, and you can tell me if there's an issue, which typically there is not. Mr. Singleton, other than what we've addressed here today, is there anything else you think I need to address?
No, Your Honor.
That's excellent.
Thank you. So see you Tuesday?
What was that?
I'll see you Tuesday?
Yep.
All right.
All gangs now.